will be contributing to the discussion. Your presentation this morning before the committee is proposed for 15 minutes and present within that time frame. But just quickly, before you begin to introduce members of the committee, starting from to my right is Deputy Chairman of the Joint Select Committee, Senator King. And to my left, Senator Rogers, Senator Brathwaite, Miss Cynthia Ford, and of course, the chairman of the committee, Tony Moore. Other members present in the room, you'd recognize Minister Kirk Humphrey, who is in the Ministry of People Empowerment. We have another committee member back online, the Honourable Corey Lane. Also present is Minister Abrams, Minister of Home Affairs. Respectively, the ministers are the line ministers responsible for the Child Protection and the Child Justice Bill. And it is over to you. Oh, and of course, how can I forget the main, the very technical support that we have in the person of Ms. Bell, who I'm sure you all are familiar with. So over to you, Ms. Margot Green, for your submission.
Good afternoon, ma'am. I'm very grateful for the opportunity to be presenting here today. My name is Kay Williams, Barbados Bar Association, and allow me to introduce, as you said, Ms. Margot Green and Ms. Pettigale Brace. Very important because they are senior practitioners in the family law area, and we are grateful that they are here today. We won't be able to go through the bill, as you appreciate, the two bills in great detail, but we would raise certain areas of concern that we have, and then we will follow with our written submissions. Thank you.
Thank you.
Thank you. Good afternoon to everybody. I will start first to deal with the Child Protection Bill. What we propose to do is to go through section by section as far as that is possible and make comments, and then we will listen to your questions and try to answer them. First, let me say that this legislation codifies, in some respects, some of the practices which are now ongoing in the family court, but it also introduces quite a lot of new ideas and novel approaches to how one deals with children, which we have found quite interesting. And actually, what we propose to do is a comprehensive written submission for you, if you wish it at a later stage. But the notification came too late for us to go through it and do it within the time that you asked. I will start first with the definition section of the bill. And I'll start, if you don't mind, we'll go by page numbers, make it easy. Page 11, the definition of child. I notice here that child is defined as a person who is under the age of 18 years. What concerns me about this definition is that there are other pieces of legislation that allow someone who's under the age of 18 years to participate in what would normally be regarded as adult activity. So, under the Marriage Act, a person who has attained the age of 16 years can get married, which, as you would appreciate, is certainly an adult activity. And a person who has attained the age of 16 years can consent to sexual intercourse. So I would think that we need to look again at the definition of child. Even though it accords with the Family Law Act, there are other pieces of legislation with which this definition would conflict. And if we're dealing with all children, and not just children who are born to married parents or parents in a union other than a marriage, as happens under the Family Law Act, then we need to make the definition a lot broader than simply a person who has attained the age of who's under the age of 18 years. I next go to page 13. And we're looking specifically at the terms abuse, emotional abuse. We had a difficulty with the definition of emotional abuse causing psychological pain. I don't know how that is going to be proved. I imagine that in order for that to be satisfactorily proved, you will have to have a psychological intervention by a psychologist. And you'll also have to go on to prove that that psychological pain will cause significant harm. We also had a difficulty with the term financial abuse. If you will see, it says it means the exercise of control by a perpetrator over a child's access to financial resources through coercion, deception, or intimidation, the effect of which is to hinder the ability to maintain a child, and includes withholding the financial support necessary to maintain a child. We had a difficulty with the second part, which starts from the sentence, and includes withholding the financial support necessary to maintain a child. Normally, financial support necessary to maintain a child is given to the parent of the child or the guardian of the child, and not to the child directly. We thought that financial abuse would mean something which more directly affected the child, such as if that child was, say, a beneficiary of a trust or had earned money in his or her own right, and someone was trying to deprive the child of access to that money. That would more be financial abuse as it relates to a child, rather than withholding financial support. I believe 45% of the men in Barbados will be guilty of this if you allow this definition to continue, from what I see in my practice, if not a larger percentage. Physical abuse, on the next page. I found the definition of parent to be interesting, since it starts so only with a person at law liable to maintain a child or entitled to his custody, rather than simply a person to whom the child is born. So if you become a parent simply because you have a liability to maintain, that seems rather broad to me. The adoptive parents, that stands to reason, as well as the guardian. Physical abuse. I'm not sure, under the definition of physical abuse, why we speak of an act or omission. I can't think of any omission that is likely to cause physical abuse. So maybe the drafters of the legislation need to look at that again. What omission could? Pardon me?
Any act which causes pain is too light.
Yeah. Another part of the definition that we had a problem with is any act or omission which causes pain, or we consider that to be far too wide and too vague.
This is on page 14 on the physical abuse stuff?
Yes, my lady. Yes,
Okay.
ma'am. Yeah. We also didn't understand why bullying was under physical abuse. So we thought that you need to look at that again. I don't think that bullying is always or mainly physical. I didn't think it was physical at all, however. The next problem, the next section that we looked at, page 16. section 3.2 at the bottom of the page. In determining what is in the best interest of the child, the following matters shall be taken into account. And it recites A to J. Where we were concerned about was where appropriate, at E, page 17, the views of the child. Inasmuch as you've defined child as anybody who's under the age of 18, this could be a 6-year-old, a 4-year-old, a 10-year-old. So we thought that there should be some kind of guideline as to at what age would you be looking at the views of the child. Because views of children who are immature or are really very young may not necessarily be of any interest or of any help to anybody who's contemplating what should be done with them. Yeah. If you want to use as an example the Family Law Act, a child is allowed to have a say in where he or she lives or with whom he or she lives at the age of 16. Inasmuch as this act covers far wider circumstances than the Family Law Act, you might wish to look at a younger age. But I think we thought that there should be some kind of age limit where you look at the age of the child. Similarly, in section 4, on that same page, page 17, where it says, the following principles shall be applied in the administration of this act. And it says, where a child is able to form his own views concerning his safety or welfare, he shall be afforded an opportunity to freely express his views. And again, we felt that there should be an age limit or some kind of guidance as to when this should happen, and also how it should happen. How are you going to extract these views from this child? So we felt that that section was a bit too vague. And on page 18, where you say where a child is temporarily or permanently deprived of his family environment or cannot be allowed to continue in that environment in his best interest, the child shall be entitled to special protection and assistance from the government of Barbados. We are not sure what that means, since I felt that all children should be entitled to the special protection and assistance from the government of Barbados. What does it mean by special protection is that may be regarded as discriminatory, but I think perhaps you need to look at that again. Or are children only entitled to special protection if they are removed from the environment in which they normally live? And further down on page 18, same page, a child is in need of care and protection where he does not have a parent who is fit to exercise care or guardianship owing to mental or bodily disease. I would hope that this act has, that we will go on to define, probably in subsidiary legislation, what would be a mental disease. I think that's rather broad. I can understand a physical or bodily disease, but a mental disease? And on page 19, I think that would be section, come on to section F, where a child has been exposed to danger, moral or otherwise. I think that is too, well, we felt that it was too vague. We were not quite sure, and could also be subjective, what is meant by moral danger. And at paragraph G, where the child has suffered physical, emotional, or psychological harm caused by being exposed to domestic violence by or towards a parent or other person residing with the child, we felt that in this section, both the perpetrator of the domestic violence and the victim of domestic violence could be equally, could we say, punished by having the child removed from their care, when we didn't think that this would be fair to the victim. So the towards meant that if you just witness, let me not have a gender bias. If you witness your mother beating your father, then possibly is your father, who's the victim, going to be deprived of your company when he or she probably had, was not to blame. We felt that this section could be, could lead to unreasonable or unfair consequences. We're going to comment on H, but I'm not going to bother with that. That will take too long. And
Miss Green?
yes, ma'am. I'm finished? My
No,
15
I
minutes,
do
ma'am?
recognize that 15 minutes is upon us, and it would seem to me, I haven't seen your submission, but you are now scratching the surface because your submission is very granular, and I do apologize that 6 weeks seem not to be long enough, which scares us for you to submit your submission.
The 6 weeks fell within the court holiday when all litigators go on holiday.
Where all of the,
All litigators, and we are litigators.
go on
Anybody
holiday?
who don't go on
I
holiday.
don't know what holiday is, so tell me about it. All right, so,
What a fortunate woman you are.
yeah, what I'm
You want us to
thinking,
speed through it?
no, what I'm thinking is that, just give me a minute. So what I was thinking, is it may be more useful to the process if you are, because we are doing oral presentations again next Tuesday. That is the last day that we have assigned for that. So if your written submission can be put to us, because naturally CPC also will have to be responding, and members of the committee will have to be responding. It would help the process if we can see it.
Okay, that can be done, ma'am, because we've already started to write it out.
All right, and then we would need time to be able to review it. So would you be able to have your submission available to us by Thursday, Friday?
What's today?
Today's Tuesday,
Yes?
by
Yes.
Thursday.
Yes?
Then members of the committee will have ample opportunity to consider it and to be really fair to you and to the process as well.
Fine.
So since that is agreed,
Madam Chair, if I may, through you, ask a question.
proceed.
If there are any particular areas of interest that you may have had through your various sessions, and you would wish us to identify our views as attorneys, we would be grateful as well. I know our submissions are line by line, but if there are any questions or any particular areas that you'd be interested in hearing from us, please let us know. Thank you.
Will do. Actually, I had a question lined up for you and one that I raised with the Child Care Board as well. I would wish you to review the position of diversion for your views. We had it in a written submission where it was considered by the submitter that the process of diversion should not commence before a magistrate, notwithstanding how informal that process is intended to be, that psychologically and so on, it may be useful for the child to come before some other body before starting it at the magistrate, although it's not intended to have consequences on the child and so on. There are some views that have been expressed so far, but I'd be interested as chair to hear the Bar Association on this.
Okay. Ma'am, I'd like to ask a question myself, though I know I'm not supposed to. In as much as you want this piece of legislation to be in accordance with the international treaties to which Barbados has acceded, have you given any thought or to whether or not this piece of legislation will take into account the provisions of the Hague Convention? I noticed that the body that is created here is called the authority. The body that is usually created under the Hague Convention is the central authority. And the central authority, which we were told when Barbados acceded would be the Child Care Board, would assist those persons who have to deal with children who are abducted and brought to Barbados, or abducted and taken away from Barbados. So our question here, bearing in mind some of the provisions in this legislation, would be whether or not you contemplated having this authority being also named the central authority under the Hague Convention. You might be surprised to learn that Barbados, we have done quite a few kidnapping, what we call kidnapping cases. And if there was a central authority from which it could be done for Barbadians, they'll be in a far better position than we are at present when there is none, because it's an exceedingly expensive procedure if you have to go person to person as opposed to state to state. And here I think in section 52, you have about being able to search out children who have been taken away illegally. So I was wondering if that was in contemplation of making this the central authority, or if this session could perhaps raise the possibility that that can now happen, because we really do need a central authority in Barbados.
Ms. Bell?
Chair, just to draw the attention of the Commission and the Bar Association to Clause 67, where it's indicated that there's going to be the transition of the Child Care Board into the Child Authority. So that within those provisions, it is anticipated then that they would be the authority for the purposes of the Hague.
Oh, very good. Glory be, we need that desperately.
All right, thank you. So to you, Ms. Hines, Ms. Green, and Miss Williams. Right. I just want to thank you, and we look forward to your full written submission.
So we don't have to come back, do we?
Yes, we
We'll have to
will.
come back, okay.
Yeah,
I just wanted to
because
clarify.
notwithstanding the written submission, I'm sure that there would be areas for clarification and exchange that may facilitate the process. So we don't want to limit you to the written submission.
Very well, ma'am.
So next week, Tuesday, September the 26th at 12:45.
So you have to come back. I deliver the
12:45.
written submissions to you on Thursday and return on Tuesday. Very well, ma'am.
Thank you, ma'am.
Sorry about that. Was there a question?
Not from here, ma'am.
Okay, sorry, it was just a clarification regarding the
The
time.
time.
So 12:45 next week, Tuesday.
Yes, ma'am.
Thank you.
Thank you.
Our thanks to you, ma'am.
And Thursday close the day for the submission.
Pardon me, ma'am?
Thursday, the 21st, close of day for the submission.
I am aware, ma'am. I'm aware. You should get these things from judges and probably wear them out.
Okay, committee, before we adjourn, is there any other business? Seeing none, I wish to thank you for what I believe was a very useful session for today. We continue next Tuesday, September 26th, commencing at 10 in the morning. And you are reminded that that session next week, Tuesday, is an all day, is contemplated for a full day's work. So we look forward to seeing you then. Is there a motion to adjourn the meeting?
I ask that the meeting be adjourned.
Seconded by Senator Rogers. Thanks, committee. Thanks, Ms. Ford, sorry. Thanks, committee. Thanks, team members. Have a wonderful rest of your day.
Thank you.
Recording stopped.